The court system and judicial selection in Texas. Texas has a dual court system, a judicial structure where there are two systems in place, both a federal and a state. So the federal court system, which is a part of the national government, the U.S. government, deals with matters subject to federal law and with interstate and international disputes. The state court system deals with almost everything else that falls within a given state's borders. Most cases go to state courts rather than to federal courts. Civil cases involve disputes between individual citizens. All individuals who believe they have cause or have been injured by others may file a civil lawsuit. The standard of proof in a civil case is preponderance of the evidence, meaning a majority of the evidence. A judge or a jury may decide the case. The default is a bench trial or trial by judge, but the litigants may request a jury trial within reasonable time before the trial begins. The winning party receives some form of compensation, and people found guilty in a civil case do not go to jail. Some other examples of civil cases involve family law, marriage, divorce, child custody, age of consent, and other issues. In these cases, a judge or a jury can determine the outcome of the dispute. Criminal cases involve violations of the law, crimes against society or against the state. Representatives of the state prosecute individuals in criminal cases. The standard of proof is beyond a reasonable doubt. Individuals accused of a crime have a right to a trial by jury. The penalty can be a monetary fine, imprisonment, or both. Courts resolve individual conflicts by interpreting and enforcing existing rules and laws. Individuals must have standing to bring suit in a court. Courts do not deal in hypothetical or imaginary cases. The case must involve real controversies between two or more parties, and someone must have suffered real damage. There are strict procedural rules to determine when and how to present facts and arguments in a case. Generally, a court's decisions only affect the case that the court is considering, but decisions can also serve as precedent for parties in the future with a similar dispute. Stare decisis is the principle that court decisions depend on previous rulings of other courts. The term is Latin for to stand by that which was decided before. Grand juries determine if a person will be charged with a crime. Most grand juries serve for 6 months. Texas uses both grand juries and administrative hearings. A citizen may waive his or her right to review by a grand jury and ask that a judge review the charges. An administrative hearing is a hearing before a judge who decides if a person must stand trial. This is used in place of a grand jury. Grand juries are supposed to serve as filters to prevent arbitrary actions by prosecuting attorneys. However, they frequently follow the advice of the prosecuting attorney. During grand jury proceedings, the accused may not have an attorney present during the hearing. During an administrative hearing, the attorney is present and can protect the accused. Petit juries determine guilt or innocence of a person during a trial. A jury pool may be randomly selected from voter registration lists or from a list of licensed drivers. In criminal and civil cases, the defendant has the right to a trial by jury, but may waive this right and let the judge decide the case. In Texas, more than 1 million cases are filed in county courts each year, and fewer than 5,000 result in jury trials. Fewer than 1/3 of cases in the district courts are criminal cases. Most cases end in a plea bargain and never go to trial. In a plea bargain, the accused agrees to plead guilty in exchange for a lesser sentence. The judge can accept or reject the agreement. Texas has several levels of trial courts and appellate courts. Trial courts include justices of the peace, municipal courts, county courts, district courts, special purpose courts such as probate, juvenile, and domestic relations courts. Appellate courts include the 14 intermediate appellate courts and 2 supreme appellate courts, the Texas Supreme Court for civil appeals and the Texas Court of Criminal Appeals for criminal cases. In trial courts, the jurisdiction is limited to a geographic area such as a county or a district. Only one judge presides over a trial court, and each court is considered a separate court. Citizens serve as members of juries and as witnesses during trials. Trial courts establish the facts of a case, such as, is the person guilty? Appellate courts are centralized, often at the state level. More than one judge presides over an appellate court. There is virtually no citizen participation, such as juries or witnesses. Appellate courts decide points of law, not points of fact. So, did everyone follow the correct legal procedures is a question that appellate courts are interested in. In Texas, all death penalty cases are automatically appealed to the Texas Court of Criminal Appeals. The Texas State Legislature creates municipal courts by statute. Municipal court judges are either appointed by city councils or elected. Some jurisdictions require municipal court judges to be attorneys, others do not. Some municipal courts are courts of record. A court reporter transcribes all the court's hearings and trials. Appeals to county courts from these courts have a transcript that the higher court can review for errors. Most municipal courts create no such record, so the county court considers any case brought up on appeal de novo. The appeal starts with a blank slate, as if no court has heard the claim before. Municipal courts hear cases involving violations of city ordinances, most often traffic violations. They can hear other misdemeanor cases. Municipal judges can also issue arrest warrants. The Texas Constitution creates justices of the peace. JPs, or justices of the peace, are not required to be attorneys. They do not create a record of their proceedings for a county court to review. So all appeals from JP courts are de novo. There is a new trial at the county level. JPs can issue search and arrest warrants. They hear minor criminal cases. Most involve traffic tickets issued by the Texas Highway Patrol or county deputy sheriffs. JP courts also serve as small claims courts. Municipal courts do not. Jurisdiction in small claims court is limited to $10,000 or less. Most JP cases in fiscal year 2016 were criminal misdemeanor cases, about 83%. 68% of those were traffic cases. Only 17% of JP cases were civil cases. JPs can also perform marriages. They charge a fee for performing marriages. Municipal judges have fought unsuccessfully to also have this power. There are two main kinds of county courts: constitutional county courts and county courts at law. County courts at law are created in large urban counties where the county judge becomes almost exclusively an administrative officer or county executive. County courts primarily hear intermediate civil and criminal cases. Most criminal cases are misdemeanors. County courts also serve as appellate courts for cases heard by JP and municipal courts. District courts hear major criminal and civil cases. The jurisdiction of these courts often overlaps with county courts, and cases may be heard in either court. Texas has 14 courts of appeal, with 80 judges elected by districts in the state. They hear all civil appeals cases and all criminal appeals, except those involving the death penalty, which go directly to the Court of Criminal Appeals. The Texas Supreme Court is the highest court in Texas for civil matters. The Court of Criminal Appeals is the highest court in Texas for criminal cases. Each court has 9 judges elected statewide for 6-year overlapping terms. Article 15 of the Texas Constitution says that the Texas Supreme Court can remove a judge for partiality or oppression or official misconduct, or if the judge's habits render him unfit to hold office. By 2/3 vote of the Texas legislature, the governor can remove a judge from office for neglect of duty, habitual drunkenness, or oppression in office. A 2/3 vote of the state senate can remove a judge in an impeachment process. District judges may remove county judges and justices of the peace. In Texas, trial court judges are elected in partisan elections for 4-year terms, and appellate court judges are elected in partisan elections for 6-year terms. Municipal court judges are usually appointed by the mayor or the city council. In 2017, Texas passed a bill ending straight-ticket voting beginning in 2020, forcing voters to manually select their desired candidate. Under Texas's partisan election system, judges must win nomination in the party primary and then win in the general election. The majority of campaign contributions come from business, energy, finance, insurance, and real estate, as well as lawyers and lobbyists. In 2006, a group called Texans for Public Justice issued a study which said that the Texas Supreme Court was more likely to hear cases filed by large contributors. It accepted only about 11% of all petitions filed, but it was 7.5 times as likely to accept a case if the cases were filed by contributors of $100,000. And it was 10 times more likely if the contributors had contributed $250,000. Judicial selection refers to the process used to select judges for courts. At the state level, methods of judicial selection vary substantially in the United States, and in some cases between different court types within a state. Here are 6 types of judicial selection. First, a partisan election is when judges are elected by the people and candidates are listed on the ballot alongside a label designating political party affiliation. 2, in a nonpartisan election, judges are elected by the people and candidates are listed on the ballot without a label designating party affiliation. 3, the Michigan-Ohio method is where the state Supreme Court justices are selected through nonpartisan elections, preceded by either partisan primaries or conventions. 4, a retention election is a periodic process whereby voters are asked whether an incumbent judge should remain in office for another term. Judges are not selected for initial terms in office using this election method. Assisted appointment, also known as merit selection or the Missouri Plan, is when a nominating commission reviews the qualifications of judicial candidates and submits a list of names to the governor, who appoints a judge from the list. Direct appointment is number 6. Judges are appointed by the governor, sometimes with approval of the state legislature required, or judges are selected by the state legislature. A judge in Texas must be a U.S. citizen, a resident of Texas, licensed to practice law in the state of Texas. The judge must be between the ages of 35 and 75, and must be a practicing lawyer and/or have been a judge for at least 10 years. Now, although no judge older than 74 may run for office, sitting judges who turn 75 are permitted to remain on the court until their terms expire. The 9 justices of the Supreme Court and the Texas Court of Criminal Appeals are selected in statewide partisan elections. The judges on the Texas Courts of Appeals are selected in district-level partisan elections. The elected judges serve 6-year terms, after which they must run for re-election if they wish to remain on the court. In the event of a midterm vacancy, the governor appoints a replacement who must be confirmed by the Texas Senate. The appointee serves until the next general election, in which he or she may compete to serve for the remainder of the unexpired term. The Chief Justice is the chief judge or justice of each court, and is selected by voters at large. He or she serves in that capacity for a full 6-year term. The judges of the Texas District Courts are chosen in partisan elections. They serve 4-year terms, after which they must run for re-election if they wish to remain on the court. To serve in the district courts, a judge must be a U.S. citizen, a resident of Texas, licensed to practice law in the state, and must be between the ages of 25 and 75. While no judge older than 74 may run for office, sitting judges who turn 75 are permitted to remain on the court until their term expires. Also, a judge must be a practicing lawyer and or have been a state judge for at least 4 years, and must be a resident of his or her respective judicial district for at least 2 years. The district courts fill vacancies by gubernatorial appointment with Senate approval. The judges serve until the next general election, at which point they may compete to fill the remainder of the unexpired term. Judges on the constitutional county courts are elected in partisan elections at a county level. They serve 4-year terms with vacancies filled by a vote of the county commissioners. All of Texas's 254 counties have a constitutional county court, and the judges serve ex officio as the head of each county's commissioner's court. Judges of these courts need not have a law license, and the only qualification for office is that a candidate shall be well informed in the law of the state. Judges on the statutory county courts are elected in partisan elections at a county level. They serve 4-year terms with vacancies filled by a vote of the county commissioners. The statutory county courts, called county courts at law, were established by the Texas legislature. To serve on a county court, a judge must be at least 25 years old, be a resident of his or her respective county for at least 2 years, and have practiced law or served as a judge for at least 4 years preceding the election. Judges on the Texas statutory probate courts are elected in county-level partisan elections. They serve 4-year terms with vacancies filled by a vote of the county commissioners. The probate courts were established by the Texas state legislature. To serve on a county court at law, a judge must be at least 25 years old, be a resident of his or her respective county for at least 2 years, and have practiced law or served as a judge for at least 4 years preceding the election. The members of the Texas Justice of the Peace Courts are elected in partisan elections and serve 4-year terms. They are elected in a precinct-wide election. To serve as a Justice of the Peace, justices must complete a 40-hour course on relevant duties within 1 year of the election. They must also complete a similar 20-hour course each year they continue to serve. The rules regarding judges of the Texas municipal courts vary by each city's charter. Most municipal judges are appointed to a 2-year term by the city's governing body, though some compete in partisan elections.